For government parliament, item number 1.
For reasons mentioned in the judgment, the criminal petition is dismissed. However, considering the fact that the further investigation has taken, the incident has happened long ago, the learned magistrate may fix a specific period for completion of further investigation. And till the supplementary report is filed, the petitioner shall be at liberty to approach the learned magistrate to dispense with her personal appearance before the magistrate court. With this observation, this criminal petition is hereby disposed of.
Item number 1.
Let the matter come along with Lordship BA 408 Lordship, of the same accused person Lordship, fixed on 5 Lordship. 5.
Why it has come to my court?
Because Lordship have rejected it.
This has been rejected.
Yeah.
Okay. Heard Mr. S. Munir, learned counsel for the petitioner, who submits that a bail application concerning the same PS case number, same
accused person.
same accused person has been fixed on
5-3 Lordship.
5th of March and request this bail application to be placed along with the same application.
BA 408.
Let this, the prayer is allowed. Let this bail application be listed again on 5th of March along with
BA
bail
408.
application number 406
408
of
2024.
2024.
Lordship. Much obliged. Much obliged. 408.
First take note.
Item 2.
Oh.
Item number 2.
None appears for the appellant. Counsel is there? Any,
She's there, Lordship. I saw her
who?
morning.
Miss Sharma?
Yes. So maybe.
We will take it up because we don't have much time left.
Yes, yes.
None appears for the appellant on call. Let this matter be listed again after a week.
Item 3.
Now, applicable, Mr. K. Bashir, additional public prosecutor is present, and Ms. L. Devi is appearing for. You are appearing for?
Corresponding to Lordship.
Respondent number 4 is present.
This matter pertains to a quashing of the proceeding, which is pending before the learned court in Tawang. The proceeding has started out of an FIR lodged by the Deputy Commissioner with an allegation of disobedience of the order of demolition passed by himself.
No, just a minute. Before you start. This is for final disposal.
Yes, madam.
Why?
It is part heard.
Okay, why? We have heard it earlier.
Yes, the non-compliance of section 195 CRPC, basically.
Okay. Why this has been pending before principal seat matter pertaining to Arunachal Pradesh?
Because in the earlier round of litigation, in the first case, my lord, which was filed before the Itanagar permanent bench, the criminal petition was allowed by the court, holding that under section 195,
This court, Itanagar bench allowed.
allowed the criminal petition.
Okay.
Being aggrieved, I have prepared a short compilation for the convenience of this honorable court, narrating the facts in short. In the first page, I have narrated the facts, date-wise. 17/8/2012. The petitioner applied for this allotment and all this. The first order, your lordship will find at page 12
Page 12 of the.
of the compilation I have just
Okay,
submitted,
Okay,
volume 1. This was registered as criminal petition number 17 of 2020.
okay.
The order is available at page 12. Paragraph 2.
It was disposed of by order dated
16/3/2020.
Then what happened? What was the order?
Well, order, your lordship will find as page 12, the relevant portion, if I may
Then-
take your lordship straight away to page 13.
What relief you were seeking? You are seeking.
Quashing the FIR.
Okay.
Because the contention was that as per section 195 CRPC, any offense enumerated under section 182 to 188 cannot be initiated on the basis of a police report. The relevant portion your lordship will find at page 13, page 6,
Page 13.
page 13, paragraph 6, sorry. For the facts, if I may take your lordship to paragraph 4 first. The previous page, page 12. Mr. So-and-so, learned counsel appearing for the petitioner, refer to the different provisions of the Arunachal Pradesh Public Premises Eviction of Unauthorized Occupants Act 2003. Mr. So-and-so, learned counsel has submitted that without giving an opportunity of hearing to the petitioner, a criminal case has been filed against him.
No, you have not answered. Why this came to principal seat?
Because it went up to Supreme Court. Supreme Court made an observation without making any observation on the merit, send it back to the principal bench. And the criminal petition was renumbered as it is now.
Okay, then it was not sent back to Arunachal.
No, my lord, the order is available here. Your lordship will find the order of the Supreme Court.
Okay,
Because the basic ground of challenge with the Supreme Court was that the petitioner herein is a standing public prosecutor in Arunachal Pradesh. So when the criminal petition was moved by one of the private advocate, it was the contention, it was the argument of them before the Supreme Court that somehow the judgment was passed in influence of the learned PP.
therefore it is before this.
Yes, the order is available at page 14, which clearly says Supreme Court's order. We are satisfied that the High Court procedurally went wrong in disposing of the criminal petition number so-and-so. We therefore set aside the order and remand the matter to the High Court for fresh disposal in accordance with law. Let it be made clear, we have not gone into the merits of the case. The special
What was argued? What procedural wrong was there?
because the basic argument was that the petitioner,
No, there is an observation that High Court procedurally
But-
went wrong.
this was the procedure, because the learned PP, the standing PP of the Arunachal Pradesh was the petitioner in the case.
Okay,
And additional PPs, whoever was appearing, favored that,
but he did not object.
yes.
Okay,
So somehow out of colleague, that was the apprehension that they have influenced. The petitioner has
so
influenced,
in that context, this observation has been made procedurally when.
yes, and that was the,
Is it so?
and that was the ground taken by them in the SLP.
And secondly, my lord, one Y Riram and then APP had impersonated themselves as then advocate for the answering respondent, my lord, and for the first informant, that means respondent number 2, and he was without any instructions received no instruction from the the respondent number two, then respondent number two, he has demitted his office now,
Okay, these were pleaded before
the
Supreme Court.
And so accordingly, in terms of the Bar Council of Act rules, we have filed a complaint against him.
Those.
Yes.
lawyers.
So nothing was commented on the merit of the case so far as the ground taken in the criminal petition is concerned. So that's how this matter came before this principal bench.
Okay, now proceed with para 4.
Para 4. Mr. So-and-so learned counsel appearing for the petitioner refer to the different provisions of the Arunachal Pradesh Public Premises Eviction of Unauthorized Occupants Act 2003. Mr. So-and-so learned counsel has submitted that without giving an opportunity of hearing to the petitioner, a criminal case has been filed against him. The learned counsel for the petitioner further submits that as many as 5 persons, including the petitioner, had taken over a land and constructed buildings over those lands, but no action has been taken against those other persons except the present petitioner, namely Jambe, Sering, and another. According to the learned counsel, the aforesaid FIR has been filed with a mala fide intention only to harass the petitioner hearing. Further, Mr. So-and-so learned counsel for the petitioner has also submitted that the FIR dated 14/8/2019 and Tawang PS case number 14 of 2019 arising out of the said FIR is frivolous, vexatious, and without substance. But to harass the petitioner by respondent number 2 for the reasons that the petitioner as advocate presented against him in title suit number 10 of 2018 in another case and in complaint case number 6 of 2014. The learned additional PP Mr. So-and-so has agreed to the submission made by Mr. T.T. Tara, learned counsel for the petitioner. Whenever a person, paragraph 6, whenever a person occupies a public property, the procedure is laid down in the Act of 2003. There is nothing on record to show that the aforesaid deputy commissioner who had lodged the FIR was appointed as an estate officer under section 3 of the Act of 2003. In the state of Haryana and others versus Bhajanlal and others reported in so-and-so, the Honorable Supreme Court has held that where a criminal proceeding is manifestly attended with mala fide or where the proceeding is maliciously instituted with an ulterior for wreaking vengeance on the accused and with a view to speed him due to private and personal grudge. Today, after hearing both the sides and considering the materials available on record, I find that the aforesaid FIR lodged by the Deputy Commissioner Tawang District is against the procedure of law as laid down in the Act of 2003. Therefore, the FIR dated 14/8/2019 being registered as Tawang PS.
What is there in 2003 Act?
2003 Act is the last occasion I have submitted.
When it was last heard?
Long
Which date?
Act.
Do you remember the date? No.
Yes.
Six 11/23.
6/11,
Yes,
6/11, yes. Okay.
So in this manner, the proceeding, the FIR was quashed by the learned court. After that, it was challenged on before the Supreme Court on some ground as has been highlighted in the petition. Now, when the matter came back here, an order was passed on 12/8/2021 in the Itanagar bench, which is available at page 70.
Page
17. Heard Mr. So-and-so, the lordship has got
yes.
order at 12/8/2021, page 17. Heard Mr. So-and-so,
Yes.
learned counsel for the petitioner. Also heard Mr. So-and-so, learned senior government advocate representing respondent number 2, and Mr. So-and-so, learned additional public prosecutor representing respondent number 1, 3, and 4. The case is restored to file in view of the Honorable Supreme Court order dated 30/7/2021, passed in SLP criminal number so and so. Let notice be issued to the respondents, returnable within 6 weeks, since Mr. S. Tapin, learned senior government advocate representing respondent number 2, and Ms. T. Jenny, learned additional public prosecutor representing respondent number 1, 3, and 4, have entered appearance and accepted notices on behalf of the respective respondents. No formal notice need be issued. However, requisite extra copies of the petition be served from them. Call for the case diary. After hearing the learned advocates of both sides, it is provided that the further investigation of the FIR dated 14/8/2019, registered as Tawang PS case number 14 of 2019, under section 188 of the Indian Penal Code 1860, read with section 14(1) of the Arunachal Pradesh Public Premises Unauthorized Occupancy Act 2003 shall remain stayed. After returning back from the Honorable Supreme Court, that was the first order passed by the Itanagar bench, whereby the investigation was stayed. Thereafter, they filed a interlocutory application, the respondent hearing, for vacating the order of stay granted on that day. The order is available at page 19.
Yes,
The order dated 3/11/2021.
yes,
If I may read from paragraph 2.
yes,
By way of this interlocutory application, the applicant respondent number 2 has sought for recalling and vacating the interim order dated 12/8/2021, passed in the criminal petition 17 AP 2020, renumbered as criminal petition number 448 of 2021, on being transferred from Arunachal Pradesh to the principal seat at Guwahati. Briefly stated, the respondent number 1 herein as petitioner in criminal petition number so and so preferred a petition under section 482 CRPC for quashing and setting aside the FIR pertaining to Tawang PS case number so and so under section 188 IPC, read with section 14(1) of the Arunachal Pradesh Public Premises Eviction of Unauthorized Occupancy Act 2003, which was registered as criminal petition number 17 of 2020, on the ground that, without giving an opportunity to the petitioner of being heard, a criminal case has been filed against him with malafide intention only to harass the respondent number 1, petitioner, whereas the Act of 2003 provides certain procedure for eviction of the unauthorized person occupying government land illegally to be drawn by the estate officer. Paragraph 4. On the basis of the aforesaid petition, and after hearing the learned counsel for the respondent number 1, petitioner, and the learned counsel for the state, on the day of motion, this court by the order dated so and so set aside the aforesaid FIR pertaining to the Tawang PS case number so and so. The aforesaid order was challenged before the Honorable Supreme Court by the present applicant respondent number so and so. The Honorable Apex Court set aside the order of this court of the single bench, and the matter was remanded back for disposal in accordance with law, holding that the High Court procedurally went wrong in disposing of the criminal petition number so and so. We may skip paragraph 5. Paragraph 6. At this juncture, the applicant herein has come forward with the present application for vacating the order dated 12/8/2021, passed by this court, wherever the investigation has been stayed. Whereas the aforesaid case has already been charge sheeted on 16/3/2020, that is prior to passing of the impugn order, that is 12/8/2021, and the respondent number 1 petitioner, by suppressing the fact, has prayed for closure of the case before the trial court, referring to the order dated 16/3/2020. On the basis of the same, the learned trial court has closed the proceeding, which is stated to be bad in law, and such interim order dated 12/8/2021 cannot be sustained and liable to be vacated. It is challenged that both the orders dated 16/3/2020 as well as 12/8/2021 have been obtained by suppressing material facts by misleading the court, and on that score alone, the petition under section 482 CRPC filed by the respondent is liable to be quashed. Then we may skip paragraph 7, 8, and 9. We may straight away come to paragraph 10. Challenging certain other aspects on merit of the case, it is submitted that the applicant respondent number 2, misusing his official position and power, has lodged the complaint in his official capacity and contended the FIR pertaining to the aforesaid case under section 188 IPC is void ab initio and the application is liable to be dismissed. That was our submission. Then the finding of the court, your lordship will find from paragraph 14. Now, going by the background of the case, it is an admitted position that on earlier occasion, this court on the petition so filed by the respondent number 1, petitioner under section 482 CRPC, set aside the Tawang PS case number so and so, and as the aforesaid order quashed and set aside by the Honorable Supreme Court, and the criminal petition number 17 of 2020 was restored to the file, this court-wide order dated 12/8/2021 stayed the investigation of the aforesaid police station case on the prayer of the respondent petitioner hearing. The record also reveals that on the basis of the submission of the respondent number 1, petitioner, the FIR pertaining to the aforesaid case has been quashed and set aside by order dated 16/3/2020. The learned trial court has also closed the GR case that was registered on the basis of the Tawang PS case number so and so. In the meantime, as the order of this court dated 16/3/2020 was set aside by the Honorable Supreme Court, the original case was restored and the investigation of the case was stayed by the impugned order of this court on 12/8/2021. From the case diary as well as the report of the IO that has been produced before this court, it reflected that accused Jambe Sering has violated the prohibitory order of the estate officer cum DC Tawang by constructing a building on the government land without any allotment order from the government. The case was registered and after completion of the investigation, charge sheet was filed on 16/3/2020. And the same was forwarded to the Honorable Court on 19/3/2020. I have gone through the case diary that has been produced, which contained the charge sheet as mentioned above, but this court refrained itself of discussing the other matter in the case diary 7 except at the stage of investigation. It is an admitted position that the case has been ended in charge sheet dated 16/3/2020, and in view of that matter, while the investigation has already been completed in the year 2020, the stay of investigation in the year 2021 itself became infructuous. It is to be noted that at the time of passing such order, no status report of the case was obtained, nor that there was any submission in this regard. So the court passed the impugned order primarily on the basis of the submission of the petitioner side, petitioner number, respondent number 1. So far as regards the contention raised by the applicant side, that the respondent was aware of filing of the charge sheet, the same cannot be brought on record as the LCR pertaining to the aforesaid case has not been produced as to whether any process was served upon the respondent after receipt of such charge sheet, 7 except the order dated 28/5/2020 passed by the learned magistrate about closure of the case, nor no any order of the court has been placed on record. So far, so good. It is an admitted position that the investigation of the aforesaid Tawang PS case number has been completed as on 16/3/2020. And that being so, the order of staying investigation virtually became inoperative and redundant in the eye of the law and fact. The resistance made by the learned counsel for the respondent petitioner is not sustainable. Although in the appropriate case, stay of investigation can be granted in a petition under section 482 CRPC. But while it is brought to the notice of the court, though the investigation has been completed, the order to stay investigation cannot survive. It was on that premise and ground the stay order was vacated, because by that time the stay order was granted staying the investigation, charge sheet was already filed. It was not known to the petitioner, that's why it could not be brought on record. Because no process was issued, that was observed in paragraph 17. Then nothing was brought on record to show that petitioner was aware about the filing of the charge sheet. Thereafter, the case proceeded on 24/3/2020. After vacating the stay order, this honorable court on 24/3/2022, available at page 28, stayed the order, stayed the proceeding of Tawang PS case number so and so the relevant paragraph is, as no hearing has taken place today, and in the light of the aforesaid order means in the preceding paragraph, in the order dated 28/2/2022, it was mentioned that an endeavor shall be made to dispose of the matter today. And if it becomes not possible, then prayer for interim may be considered. It was the last order. Then in the next paragraph, as no hearing has taken place today, and in the light of the aforesaid order, and further in the backdrop of the averments made in the petition, it is provided that till the next date fixed, the proceeding in Tawang PS case number 14 of so-and-so pending in the court of learned JMFC Tawang, AP shall remain stayed. Until then,
So again, it was stayed.
stayed, because in the last order dated 28/2/2022, there was an observation by this honorable court, then an endeavor would be made to dispose of the petition, criminal petition pending here. So when it could not happen, the court stayed the proceeding of Tawang PS case number so-and-so, which is pending before the Tawang court. And till today, it has been stayed. This is the overall background of the case. I am challenging the proceeding only on 2 counts. But first of all, under section 195 CRPC, a FIR cannot be registered for an offense under section 182 IPC. And second, when there is a procedure prescribed under an act, that procedure has to be followed.
Charge sheet has been laid under what provision?
Charge sheet,
188.
188,
Only 188.
yes.
Okay.
And the order passed by the estate officer, which is the whole subject matter of the dispute, which has arisen and culminated into charge sheet and lodging of FIR by the deputy commissioner, is available at page 5.
Page 5 of.
But the same compilation I have given. But these documents are available in the criminal petition also,
in
but
record, these are available.
yes, my lord, these are available, these orders are available in the criminal petition, but only for the purpose of convenience of this honorable court, I have compiled it with a list of dates mentioned in the page 1. Paragraph 5, your lordship has got. This is the order dated 18 June 2019. By this order, whereas
Now, what are you challenging?
I am challenging the proceeding because the proceeding cannot be initiated on the basis of a police report as contemplated under section 195 CRPC. And this is precisely the ground taken in the criminal
No,
petition.
where is, let us go through 195.
Yes.
Whether cognizance is bar or proceeding.
Yes, congratulations, Bar.
Okay.
195 CRPC.
No, before that, let me go through your prayer portion.
Yes.
I beg apology to intervene, lordship. My learned friend is for appearing for respondent number 2 and 4. Here 4 has filed the affidavit, and in that charge sheet is annexed, lordship, at page 4.
Charge sheet is there.
Yes, lordship. So together with section 188 IPC, another section is there, read with section 14(1) of the Arunachal Pradesh Public Premises Act.
That is there.
Unauthorized.
Because
con-
No, you have to be very careful because the past history of this case is not very good.
yes, but
So whatever you submit before court, you have to be very particular.
yes, I was thinking about the IPC section also, because without adding in the IPC section, no charge sheet can be laid. Because a charge sheet cannot be laid under section 14(1) of the Civil Court Act, my lord, and the acts of the
No,
Local
otherwise-
Government Act.
Otherwise, charge sheet is under
188. If 188 goes, the charge sheet will also go.
188 and one more section.
14(1),
14(1) of the Arunachal.
Arunachal Pradesh Public
Public
Premises Eviction of Unauthorized Occupants Act.
This provides a penalty.
No,
Penalty is prescribed.
Yes, Lord.
Penal provision is there.
Yes, Lord.
There is
Then-
no penal provision. There is a proceeding, there is a procedure for appeal before the appellate authority,
14.1.
14(1), if I may take your lordship.
Yeah, this is.
To understand
No, just a
section,
minute. এটা এখন হয়ে গেছে।
just now I have handed over.
That's it. Unlawfully occupied.
Okay, in section of this.
Lordship, I have annexed it in the affidavit filed by respondent number 2, pages 56 onwards.
No, 14.1 is a penal provision. You are
But-
saying that it is not.
My lord, to understand 14(1),
No. You make me understand later on. First, you have to answer. Simple and plain answer has to come. When 14.1 is saying that offenses and penalty, it is a penal provision. You can explain it, elaborate it. But you are saying no, you have to,
my lord, there is a reason because I need to go back to, my lord, for my understanding the 14(1), I have to go back to the other provisions also. Then only we can culminate into
no,
a,
but bare perusal of the section
my lord, there are
shows that it is a penal provision which prescribes
not
a
under
penalty for an offense.
penalty for an offense by the estate officer,
No,
not
but-
under CRPC.
Whatsoever, but it is a penal provision.
Well, in my humble understanding, my lord, the 14(1), if I may read,
Yes.
if any person unlawfully occupies any public premises, he shall be punishable with simple imprisonment for a term which may extend to 6 months, or with fine which may extend to 2,000 rupees, or with both, provided that a person who, having been lawfully in occupation of any public premises by virtue of any authority, continues to be in occupation of such premises after such authority has ceased to be valid, shall not be guilty of such offense. My lord, this offense, to understand this offense, my lord, we need to go back to section 4(1). And the notice issued under section 4(1). And the contents of the notice issued by the estate officer. Section 4(1) says, if the estate officer is of the opinion that any person is in unauthorized occupation on any public premises and that he should be evicted, the estate officer shall issue in the manner hereinafter provided a notice in writing calling upon all persons concerned to show cause why an order of eviction should not be made.
Now, what I understand, this act provides for both civil consequences and penal consequences. So 14 is dealing with the penal provision. And
Then, my lord, I need to take your lordship to the notice issued under section 4(1).
okay, you continue as per your flow.
No, your lordship may ask any query.
I'll be putting queries.
Yes, that would be very much helpful for me also to understand the things. So I will take your lordship to the notice first,
Yes.
18 June 2019,
Notice issued by the state officer.
state officer.
Where I can find it.
Page 5, my lord, in the compilation.
Okay.
It is a part of my criminal petition also. In the criminal petition, it is page 31.
Okay.
Whereas during the course of inspection of Tawang Township area by the land management team of DC's office, Tawang, it was observed that Shri Jambe Sering was found constructing building near Circuit House, Tawang, illegally without any land allotment order whatsoever. And whereas the ADC cum district estate officer,
Notice is dated 18th or 8th?
18th June 2019.
Okay, 18/6. Yes.
Was found constructing building near Circuit House, Tawang, illegally without any allotment order whatsoever.
Jambe Sharing is present,
Petitioner.
he is the present public.
Present public prosecutor of Arunachal Pradesh. And whereas the ADC cum district estate officer Tawang district, right, order dated 8/10/2015, had issued notice under section 4(1) of the Arunachal Pradesh Public Premises Act 2003 to Sri so-and-so, Tawang, giving him an opportunity to produce papers, documents, if any, relating to the land. And whereas Sri Jambe Sering, son of so-and-so, Tawang was also directed to stop the construction of building and vacate the land within 7 days. And whereas Sri Sering, son of so-and-so, Tawang did not furnish any reply to the notice issued by number so-and-so dated 8 October 2015 by ADC cum District Estate Officer Tawang till date. And whereas in the meantime, Sri Sering submitted a representation to the Deputy Commissioner Tawang, referring to his earlier representations on 2/3/2016, inter alia admitting that he has occupied the government land illegally since last 5 years and has requested the Deputy Commissioner Tawang to consider the case for allotment. Whereas the representation dated was replied by the Deputy Commissioner Tawang by letter number so-and-so dated 9/5/2018. And whereas the Deputy Commissioner Tawang has by letter number so-and-so informed Sri Sering that submission of representation do not ipso facto confer any right to anyone to illegally occupy government land and undertake construction of building thereon. And Sri Sering has also been informed that his representation cannot be considered. And whereas Sri so-and-so has not submitted any reply to the said letter notice issued by the Deputy Commissioner Tawang till date. And whereas another notice was issued on 30th October 2018 by the in-charge ADC cum District Estate Officer Tawang under section 4(1) of Arunachal Pradesh Public Premises Act 2003, directing Mr. So-and-so to remove the said building within 15 days from the date of issue of the notice, following which the said building will be evicted, dismantled, and the cost of demolition shall be borne by the building owner. This paragraph is important. I will come to this later on. And whereas it has been observed with serious concern that even after issue of the notices, without bothering to reply to the above notices by Sri Sering, has undertaken the construction work of RCC building on the said plot of land again. Further, the building under construction is adjacent to the government quarters and is touching the government quarters. And whereas, as per the direction of the government, white number so-and-so dated 1/9/2018, for allotment of any land to any individual, the minimum distance required is 1 meter. Hence, there is no scope whatsoever.
What is the Tawang case number?
Tawang case number 14 of 2019.
What case is this? GR or
GR case.
GR case number 14 of? Now charge sheet has been laid,
Yes.
so 15.
14/2019.
Tawang PS case number.
Yes.
After laying of charge sheet, whether any new nomenclature has been given to the case, PRC case or GR case?
Not yet, my lord.
Okay.
I don't know.
Because the case was not proceeded after the stay order passed by this honorable court.
Okay. And in this case, you have challenged the FIR which led to filing of charge sheet.
Yes.
You are not challenging this notice under section 4.
Well, we filed an appeal. There is a provision for appeal. We filed an appeal,
Different
but
proceeding is going on.
unfortunately, the appellate authority is the same person who has lost the FIR.
No, but a different, you have,
No,
Before
they
the-
did not even accept my appeal because the person to whom
but this is not question in this proceeding before us.
this is not the question.
Okay. Okay. Proceed.
If I may continue. Now, whereas as per the direction of the government by number so-and-so dated so-and-so for allotment of any land to any individual, the minimum distance required is 1 meter. And there is no scope whatsoever for consideration of allotment of the said land in any case. And whereas final notice was issued by number so-and-so under section 4(1) of Arunachal Pradesh Public Premises Eviction of Unauthorized Occupant Act 2003 by this office to Sri so-and-so, to dismantle the aforesaid building within 7 days, but no action has been taken by him. In view of the fact that several notices were issued earlier by the ADC cum District Estate Officer Tawang, white number so and so, these are all the details of the notices. We may skip this paragraph, may come to the last paragraph. Now I therefore, I so and so, ADC cum Estate Officer Tawang, empowered under section 4(1) of the Arunachal Pradesh Public Premises Eviction of Unauthorized Occupants Act 2003, do hereby direct you once again to remove the building material from the government land within 7 days from the date of issue of this notice, failing which, this line is important. The said RCC structure will be removed, dismantled by this office at the cost of demolition shall be recovered from you. But this was the recourse available to the district authority to dismantle the building, recovering the cost from the petitioner himself. But they did not proceed with that action. What they have done, the deputy commissioner, for his personal benefit and to wreak his personal vengeance, lodged an FIR before the police station.
No, Acha, you make me understand how the penalty prescribed in section 14 would be imposed. What proceeding is to be followed for taking recourse to section 14 of the Act? You have to file an FIR or complaint.
Complaint.
Where is the provision?
But the estate deputy commissioner himself is
No, whether Act provides for that for the of. Because this Act provides for civil consequences also, as well as penal provision is there in section 14. Now we are concerned only with section 14. Because section 15 says Code of Criminal Procedure shall be applicable.
but it is there in the section 11.
These queries you have to answer.
Yes, sir.
Section 11 is a different thing. It relates to power of estate officer. Section 15 says CRPC shall be applicable. If CRPC shall be applicable, the penalty prescribed is less than 3 years. So it is triable by magistrate court. And criminal proceeding may be initiated either by FIR or by complaint. That is my understanding.
Well, before that, the appeal provision is there. Before
No,
convicting me,
that is,
before convicting me, before invocation of section 14, there is a provision for appeal. But this order is appealable. This order passed under section 4(1) is appealable under section 12(1). After that,
no, where it is provided that only after exhausting the provision of appeal.
well, it is written, an appeal shall lie from every order of the estate officer made in respect of any public premises under section 5 or section 7 or section 8 or section 10 to an appellate officer who shall be the deputy commissioner of the district in which the public premises are situated.
But
Well,
that is
section-
not before this court now. Now we are concerned with the criminal side. That is section 14 only. Whether this act provides that 14 will be taken recourse to only after exhausting all civil provisions of the act. How a proceeding under section 14 would be initiated under this act?
Well, section 13 is,
No, you answer my query on next date. How a proceeding under section 14 may be
implemented.
initiated, whether by filing a FIR, it can be done or not. Because section 15 says CRPC would be applicable in-
Yes.
for the offenses of this act also. So apparently it appears that recourse to filing of FIR may also be taken. On that, you want to clarify. You have to also clarify.
Lordship.
Yes.
We will continue on some other day.
Yes.
When can we continue?
Any date, my lord, if
It-
within a week, my lord.
Yes.
A long
Otherwise,
time.
if it is long enough, if it goes long, I'll again forget.
A long pending case, my, that's why it will be rest for all.
You suggested it.
March first week,
7 months, one.
Okay.
okay, my lord.
7th March is,
Yes, yes,
okay.
yes, yes.
Heard Mr. D. Mojumdar,
As Vishwas, my lord.
sorry, heard Mr. S. Vishwas. Your name is not shown in the account.
Not there, but I belong to the same chamber, so my lord.
Okay, heard Mr. S. Vishwas, learned counsel for the petitioner. Also heard Mr. NNB Majumdar, learned, and sorry, NNB Chaudhary. Appearing, you are appearing as public prosecutor. Learned public prosecutor, Arunachal Pradesh, appearing for respondent number 4. Also heard Ms. B. Chaudhary, appearing for respondent number 2.
Yes, Lord.
Who is for respondent number 1?
My learned friend, Lordship. State of Arunachal Pradesh. Lordship, he can appear.
Your government, Mr. Arun Chandran appears for Arun Chandran, learned additional senior government counsel for the state of Arunachal Pradesh, appears for respondent number 1. The hearing remains inconclusive. Let this case be listed again on 7th of,
My lord, if not inconvenient to my learned friends, my lord, can it be on fifth, my lord?
Not on fifth, Lordship. Any date thereafter or even
let it
before.
be 7th. 7th is a hearing date. 7th of March as part heard matter.
Obliged, my lord.